Now, the co-defendant, was he the driver of the car? Was he the apparent shooter, or was your client the shooter?
So they were both shooters.
They were both shooters.
Yeah.
So there was two guns involved.
Correct.
And did they ever recover the weapons?
They never recovered the weapons.
What about the casings on the floor?
Casings, they did, yes.
Gotham Investigations. We are here with Carolle El-Naffy, one of the top defense attorneys in the state of Florida. What do you do when you have to try a case and all the evidence is against you? Carolle, explain us the case that you had and what evidence the prosecution had that went against your client.
Okay, well, thank you for having me, first of all. So I had this case a few years ago in Miami-Dade. My client at the time, he was 16. He was charged with murder. They alleged that he and one of his friends, his co-defendant, killed the victim in retaliation because the victim's brother had killed my client's brother. Now, the state had a video of the shooting, which was pretty clear as day, my client's face and the co-defendant's face killing the victim. They also had, they alleged that after the shooting, they carjacked another individual at gunpoint, and they found a fingerprint in the outside of the car matching to my client. They also had a witness that was incarcerated with my client that later became a jailhouse snitch who came to trial and testified and said that my client admitted everything to him. And they also said that they were part of a gang. So they had a gang expert talk about, this gang is affiliated and they do this sort of thing. So they had a lot of evidence against him.
Now, when you say murder charges, was it first degree, second degree? Were they looking for the death penalty?
So it was a second degree murder, but with a firearm. So if if someone's found guilty of that, then you're facing mandatory life in prison.
And did the state offer any plea bargain ahead of time?
If I'm not mistaken, I think their offer was 30 years.
30 years.
Yes.
And your client just blatantly refused.
Right. At one point, he had been in custody for about 5 years. So he was in custody about 5 years before he hired me. When he hired me, I took him to trial within 8 months. But, we even asked for a 10-year offer. At that point, he would have been 5 years in. He would have only had to do 5 years left with gain time, do about 3.5 years. And the state rejected the 10-year offer.
Now, was this a private case or was this a state-appointed Jack case?
No, it was a private case.
A private case.
Yes.
Okay. And what people don't realize is when they're represented by a private attorney, your chances are so much better than the public defender's office, which has like an abundance of cases and are just trying to plea bargain everything.
Yeah. I mean, look, I started my career as a public defender. I was a public defender in Broward for 4 years. Best job I had in my life. But, I don't ever say anything bad about public defenders. There's great public defenders out there. But the problem is that you have so many cases. So you don't have the time to spend on each case as you would as a private attorney, where you can really focus on each case.
So let's go through some of the evidence and how you were able to get over those hurdles of the evidence for the jury. And what was your tactics first in picking the jury? What were you looking for?
So we were looking for people, obviously, that there's a lot of people out there that they hear the word murder and they get shocked. First of all, people that didn't really have a reaction to murder charges. Secondly, people who have had, family disputes, things like that. There's never a justification for murder, never. However, some people say that it's understandable when it's having to do with family or you're trying to defend someone, something of that nature. So we were trying to find people that were open-minded.
So let's start with the gang and the gang expert. Was he a documented gang member from prior incidents?
No. So in order, there's a few things that a police officer, a detective has to go through to determine whether someone is a documented gang member, right? So one of the things is, have they ever admitted to being a gang member? Whether they have any tattoos or anything on their body that signals that they are a gang member. There's certain different things. In this case, we argued that this was more of a neighborhood group rather than a gang. They didn't wear any specific colors. They didn't have like a gang Bible. He didn't have any tattoos saying that he's part of a gang. He never admitted to being in a gang.
Did you have your own gang expert go against the prosecution?
We did. So we had a gang expert, a great expert. His name is David Windicher. And he actually really helped us through the depositions of the state's experts. So by the time that the state's gang expert testified at trial, when it was time for the defense to put on a case, we felt like we had done a pretty good job on the cross-examination of the state's gang expert that we didn't even call our experts.
Now, what gang were they trying to affiliate your client with, and what basis what background did they have that they were trying to say that he was part of that gang?
So it wasn't one of those known gangs. To be honest with you, I don't remember the name right now at the top of my head of the gang, but it was one of those like local Miami gangs that they were saying. And there was other people that my client was at some point in his life known to be associated with that were really part of that gang, but my client, there was no evidence that he was part of that gang.
So let's get to the carjacking. What was the evidence on that? Did they have videotape? I know you had mentioned a fingerprint. Was that part of the carjacking?
So they had a gentleman who was driving a car. He was a Marine who came to court in his uniform and everything. And he was driving, I guess, after the murder happened. He had no involvement with the murder, never heard any gunshots, nothing. And he's alleging that two young men came up to him at gunpoint, put their gun on his head, drive us to this location. And they're saying that there was a fingerprint outside of the car that matched my client, right? So they're saying, how else would his fingerprint have gone to the outside of the car if it wasn't because he was part of the carjacking?
Okay, now what did you come up with for that defense?
Well, first of all, the driver of the car who was carjacked, he was never able to ID my client. My client is Hispanic. His co-defendant is African-American. All he could say was that there was one African-American person. He never could say that there was a Hispanic person, nothing. Our argument was that my client frequented that area. He was from that neighborhood. And this person, the driver of the car, also frequented that area. There was a basketball court, a park right nearby where they both admitted in deposition that they would go to that basketball park and play basketball. So I just argued that, maybe he was just walking down the street one day, put his fingerprint, and it just happened to be there. Now, one of the main arguments was if he really was involved in the carjacking, wouldn't there have been his fingerprints inside of the car? Once you get in the car, you have to open the door handle to go outside. There was no fingerprints inside of the car that matched my client's.
Now, in every defense team, we're part of a lot, being investigations. We work for a lot of defense teams. Did you have like strategic meetings with your team, how you were going to address each part of the evidence, or was that something that you had to think quick on your feet inside the courtroom?
So, of course, I usually try my more serious cases with a co-counsel. So in this case, I had one of my friends, his name is Housen LaFrance. He tried this case with me. And of course, prior to trial and during the pendency of the case, we met several times. We discussed strategy, what are defenses to every allegation. But, there's always going to be things that happen during trial that you never expect. So you do have to be quick on your feet and think about those things then and there.
Now, you also mentioned some video evidence.
Yes. So the shooting occurred outside of a fish market. So they have video of the victim running, and then they have a video of the two people, my client and his co-defendant, getting behind him and shooting him until he hits the ground. They also have another angle of the video of them going around the fish market where literally the camera is right on his face. So it's pretty difficult to say that it wasn't him.
And what was your defense on that?
So my defense on that was, in the video, you see a Hispanic looking male, okay? It doesn't necessarily have to be him. There's many people that look like him. So in this case, it was a little difficult because the evidence with the video was so strong against him that we kind of, we fought it, but we didn't put too much emphasis on it. We thought that there was a lot of other evidence that was bad for the states that could help us say, look, at the end of the day, if you have reasonable doubts, then you must find this person not guilty. If you have reasonable doubt that this person is, in fact, or is not, in fact, the defendant, then you have to find them not guilty.
Now, the co-defendant, was he the driver of the car? Was he the apparent shooter, or was your client the shooter?
So they were both shooters.
They were both shooters.
Yeah.
There was two guns involved.
Correct.
And did they ever recover the weapons?
They never recovered the weapons.
What about the casings on the floor?
Casings, they did, yes.
And there was no fingerprints on the casing. There was nothing.
Nothing.
What type of weapon was used?
It was a Smith & Wesson.
A Smith & Wesson. And Did your client have previous arrest records involving weapons?
No. Again, my client was very young when this happened. I think he was 16 at the time that this incident occurred, so he had no prior criminal record.
No prior criminal records. Now, the co-defendant, how old was he?
So he was 18, and his story was a bit different. So in this case, we didn't go to trial with the co-defendant because he was out on probation on another felony charge. So he violated probation by committing this murder. So he unfortunately wasn't able to go to trial on the murder case because he was going to get slammed on the violation of probation. So his lawyer figured it was a better alternative for him to take a plea deal for both cases, and he got 20 years of prison.
Now, was your client going to be tried as an adult or juvenile?
An adult.
An adult. And how old was the victim in this case?
The victim was also 16.
The victim was 16. No affiliation with your client. They weren't friends. They couldn't put the connection.
No. So what the motive that the state alleged was, and this was a known fact, that the victim's brother was the defendant, a person charged with my client's brother's murder. So they're saying that it was retaliation.
So now you have a co-defendant that eventually becomes the jailhouse snitch as well?
No, so the co-defendant was not the jailhouse snitch. It was someone else. So they're saying that after the murder, supposedly my client and his co-defendant went to a house to hang out with friends, and they were bragging about what they had just done. This person, who later becomes the jailhouse snitch, is at the house saying that he heard all this bragging, later gets arrested for his own case, and cooperates with the state to testify against my client.
Now, was there any history of this jailhouse snitch being a snitch on prior cases?
Yes, and that was a big point where the jury, and this was the first time I ever saw this, he was a documented confidential informant. He had gotten paid to snitch, essentially. And I remember during trial when I asked when I asked him this on cross-examination, is the first time I ever seen the jury literally gasp. They were like, they were shocked. He even on the stand, raised his hand, pointing to the state for her to please do something. And of course, I objected, Judge, he can't ask the state to.
Can't ask for help.
Exactly.
When he's being hammered on the stand.
Exactly.
So that was another huge hurdle. Did they have any jail calls with your client outside that might have been against him?
No, he was smart enough, and he listened to his lawyers, and he did not talk about the case during jail calls.
Was that one of the first things you tell your client?
100%. 100%. Every call is recorded. The state will use them against you, so do not talk to your family or friends about the facts of the case.
I've seen so many people go down with jail calls before the trial.
Oh yeah.
And unfortunately, our motto is I know they say you're innocent until proven guilty, but on the contrary, you're kind of guilty until we could prove your innocence. In this case, how many years was he in jail?
He was in jail for almost 6 years.
Wow. So you're talking about 16, 17, 18, 19, 21, 22 years old.
Yeah.
Behind bars, this entire youth out the window, no prior charges. So now you're in trial. You have the jury that's there, obviously. Is there any particular things you were looking for in the jury? Do you try to read their faces when you talk to them? Do you address certain ones if you see that they're weak? Do you kind of put a little pressure, like raise your voice while you're looking at a certain jury member? What are your tactics?
Yeah, I mean, look, with jury, obviously you want them to like you, right? So, and, again, I don't want to, sound like, I'm the greatest attorney ever. But in this case, it's funny because it was the first time ever that a jury clapped after I did my jury selection, which I've never seen before. And so the jury liked me. They really did. And they liked the state as well. But you could tell that they felt a little bit more comfortable with my line of questioning. So you want them to like you. You want them to have an open mind. You want them to understand that, people... This is just an accusation. Again, like you said, it's innocent until proven guilty, even though, in real life, people think it's guilty until proven innocent. But just because someone's charged with something doesn't mean that they actually did it.
So when you were doing the breakdown, did you do a background on each jury member? Were you looking for ones that might have had like a criminal history, looking for ones that might not have that great of education? Were you looking at ones that may have not be financially secure.
Absolutely.
Some of them that their house might be in peril, or they might be living in a slump neighborhood. What
Absolutely.
particularly things did you look for?
I mean, some of the things you just mentioned, what happened in this case, these are people that are not, they don't grow up rich. They grow up in rougher neighborhoods. There's, gang affiliations. There's people shooting each other, retaliation. So you want people that are open-minded, people that, have grown up in not necessarily rough neighborhoods, but people that know how it is in the streets, So you want people that are able to think outside the box and not just think of the way that they grew up.
People don't realize that it's not just getting up there and putting on a show and trying the case. There's so much goes into a defense, such as the investigation into the jury. What jury members are you going to pick? The background and the history, and then you have to start on a case like this, the mitigation of the subject, just in case he gets found guilty. How can you mitigate the years behind bars? There's just a lot that goes into it. So now, how long was the jury out for?
So this case, this was in 2022. COVID was still happening. The trial itself took about 3 weeks because we had some breaks. Some members of the courtroom had COVID, so we had to break for a little bit. The jury was only out, I want to say, for about 4 hours.
Now, what's your take? Would you rather have a jury out for a long period of time, a short period of time? What has been your experience on your other cases?
I mean, look, usually the less serious cases, if they're quick, that's a good sign, like a DUI, things like that. For cases like this, murder cases, we want them to be out longer because that means that there's reasonable doubt.
4 hours is not much.
It's not that long. So, I had a good feeling. Obviously, we weren't overly confident as well either, but,
I've been to so many trials where you have zero evidence against the person, and they find them guilty.
Right.
How? No idea.
Right.
The
right.
justice system has curves and different ways it takes, and it's all depends on the jury. And now you have an abundance of evidence against you. They're out for 4 hours and come back, and here comes the final verdict. Was his family there? Did he have a lot of supporters?
And he did. He had his family there every single day. He had he still has a lot of support from his family, yes.
And what was the verdict?
It was a not guilty.
A not guilty
Yes.
verdict.
Yes.
Does he call you time to time?
I actually spoke to him yesterday, but we talk very often. He's changed his life around.
And how old is he now? He's got to be about 26,
probably like
27?
20. Yeah, he's almost 30.
Wow.
Yeah.
And he has had no prior experiences of criminal activity.
No.
Other than
no.
Before today.
Yeah, and unfortunately, people that are in the system for so long, people tend to think, oh, they're going to reoffend again. This is going to happen again. But luckily for him, he turned his life around. He works. He's doing well. He has a girlfriend. So thank God he hasn't been in trouble again.
Well, if he would have been convicted, obviously, and the jury thought he was convicted and behind bars 20, 30 years, or even if he would have been out at 15, the success stories aren't that great.
Right.
Once you're put in the institutionalized behind bars and you come back out and now you have to face society, especially at a very young age at 16. Those are your growing, and maturing ages. So you were able to turn this man's life around.
Yes.
Not guilty plea. And that, I'm sure, is not just because of your defense. It's also you took a belief in your client and his innocence.
Yeah. No, and also, like you were saying, jury selection is the most important part of a case. It really is. If you have a bad jury, doesn't matter how good your facts are, you're not going to get the right outcome. In this case, when we finished the trial, and the jury's allowed to talk to the attorneys once the trial is over, the foreperson actually walked up to my co-counsel at the time, and he told him, the state just didn't have it.
So
they weren't credible.
That was tried in Dade County?
Yeah.
Or Broward?
Dade County,
okay.
Yeah.
So if I ever cross the line and decide to turn into Barney and Clyde, I don't know which was the girl or guy, or they're both guys, but I'll be the guy, not the girl. I'll definitely reach out to you for my defense team. And if somebody wanted to get a hold of you, how would they contact you?
So you can either call me 305-456-7576 or my Instagram is at El-Naffy Law.
And what's the name of your law firm?
El-Naffy Law, PA.
And you're also certified in death penalty cases, correct?
So I'm certified as second chair in death penalty cases. I'm working towards my certification for first chair, yes.
Fantastic.
Yeah.
So there you have it. Carrolle, one of the seasoned, exceptional attorneys in the state of Florida, also previous experience as a public defender in Broward County, here to defend you. So if you thought about crossing the line and committing a crime, now you have your contact if you want to do it.
Thank you
Gotham
so much.
Investigations. We'll see you at Gotham.